Morning, everybody. Whoops, and welcome to the DC Court of Appeals. Thanks everybody for whatever heroic efforts you had to make to get here. I'm sort of surprised we didn't have any requests for remote appearances, but glad that we don't. We have two cases on this morning's regular calendar, and the first one is Derek Morris versus United States, number 23 CM 627. Mr. Burgess, whenever you're ready.
Good morning, Your Honors. My name is Tom Burgess. I represent Mr. Morris. May I please have 3 minutes for rebuttal?
Sure.
May it please the court. This case was all about the independent factor. Trial counsel for Mr. Morris brought the independent factor into the open. He cited case law that references and centers around the independent factor. The government's evidence was directed intensely towards establishing the independent factor. The moving force behind the jury instructions not making any nod toward the independent factor was not Mr. Morris's trial counsel's argument. It was an argument that came from the government, which Mr. Morris's trial counsel did accede to. And throughout this trial court was passive. These are part of the trial dynamics that I would ask the court to consider.
But do you agree that when, the request that you made or that, trial counsel made in the email about the jury instruction, that was tied up in the additional specific factor argument, right? And even though it might not have explicitly asked for, what I think you're saying now is the jury needed to hear what the government is relying on as that factor and to understand how to consider the facts that came into evidence on that. But it seems to be in the vicinity of what you're arguing now on appeal. And if if the defense lawyer said, I'm basically withdrawing my comment on that, how do we get around that, seeing that as invited error?
So I think we look to the principles underlying that doctrine, one of which is, I think, to avoid gamesmanship. And I don't see how it's to Mr. Morris's advantage or trial counsel's advantage to not have the jury adequately instructed. I think we look to the opportunity for the trial court was the trial court given the law? Did the trial court have the law in its hands to sort of also participate in the fashioning of instructions that it itself was going to give? It was the font of the elements of the law.
But again, wouldn't, even if you're saying throughout the trial, these points were being made and the judge has it, the judge knew the issue, so he should have instructed correctly. I can see that being true in the absence of any comments, but if the judge hears both parties agreeing with a certain instruction, then do we normally say, well, that was wrong and the judge knew enough? I guess this is what you're saying. That was wrong and the judge knew enough to fix it. And so therefore we should apply plain error, or in your view, even de novo review?
That the concession, so it's true, maybe there aren't a lot of cases maybe that come out that way, but I would just say that I don't think there are also a lot of cases where the issue is, all over, like the fingerprints of this independent factor are all over the case. So that would be the one sort of caveat that I would say before I would sort of pivot to if the court thinks that the error is invited. And let me just, I just want to pause on that before I pivot. It just seems a weird use. It just seems, it doesn't make sense to me to use that phrase invited error when the government is the one that invited the error.
Well, I mean, let me just push back on that for a second, right? So as you say, the defense's central argument is there has to be more than the whim of the officer, you know, ordering him to leave. There has to be some actual legal basis for the officer's order underlying that, right? And that's what everyone's talking about. And that is why defense counsel sends the email on the 19th and says, here's the law, describing it in 3 paragraphs. We want an 8th element to the instruction. Now, you could argue that the 8th element that the defense asked for didn't address the defense's concerns, but had the court granted the defense's request and said, fine, I'll give you 8 elements instead of 7, you'd agree that that's invited error, right? Had the defense gotten exactly what they wanted, all 8 elements, you couldn't come back here and say, wait a second, the jury didn't get adequately instructed about the specific additional factor.
I think that's probably correct, Your Honor.
So logically, like, there's not a whole lot of difference between that, where you're asking for an 8th element that maybe doesn't do what you really want it to do, and getting up and saying, after the government has said, well, wait, the 8th element is just the same thing as the 4th element, saying, oh, okay, well, the 4th element will suffice. Seems the same.
Well, so
as you say, it's all being driven by this concern about the specific additional factor, making sure that there's an objective basis for the order to leave.
Okay, well, so then I guess if what Your Honor is saying is true, then I would pivot to the case that I cited called White, because there's an exception to the invited error doctrine when a party makes an improvident concession. And I think that this case fits the facts of White, I mean,
White is a little bit different in that White is an improvident concession about a request for a jury demand, right? And ultimately, counsel can't waive the jury is the problem, right? But counsel does, and that's just wrong. But I take your point that the invited error doctrine, if there's really a doctrine, is kind of fuzzy at the margins. And a lot of the times we do it, and then sometimes we don't. So if I could just shift a little bit, and as you say, like, everyone was talking about this at trial. It seems to be the way that the case was tried. So if we are reviewing this issue when we're reviewing it for plain error, why do we think that this affected your client's substantial rights based on this record, where the jury was pretty much told, hey, you can't convict this guy based on the whim of the whim of an officer. Like, there has to be an objective basis, either, you know, that there's a regulation that says he can't file in the clerk's office, or, you know, that he is in fact being disruptive. Like, those are 2 objective bases, but it can't just be because the officer just decided he didn't want him to be there anymore. That's how the case was presented to the jury. Wouldn't you agree?
So I would agree that was how the case was presented. I think it would be dangerous, in my view, to rely on the way that counsel's talking about the independent factor in argument or in extracting evidence from witnesses as a substitute from a clear instruction about what it actually means to show that there is an independent factor coming from the court.
Well, clearly a clear instruction would be the best way of communicating to the jury. But if we're doing a plain error analysis, you could walk through it and say, this instruction was arguably wrong, or inadequate or deficient. But it didn't affect this individual's substantial rights because this is the way that the jury understood from both sides, from the government and the defense. I mean, there's really no dispute. This, separate, independent, the language, the terminology, I find very confusing. I'm not sure why we call it a specific additional factor. But everyone understood that that had to be shown in this case.
Well, I think there's,
So we're not talking about sort of what is proper under the law, but sort of what relief your client could get.
so, if I'm shifting from sort of the sort of dangers that I see that might happen in the deliberations, say, for example, there being a lot of focus on what, discussion about what these independent factors are. And then the jury comes back and says, okay, let's just go back to the instructions. That's what we have. And then they look at number 4 and they say, oh, he just needs lawful authority. Okay, we may disagree on all these 3 independent factors that the government has offered, but now I'm coming back to the instructions. I just see that he needs to not have authority. The officer told him not to leave. That's enough for me. Or maybe it gets jumbled up into the affirmative defense, and they start thinking, well, maybe it was Mr. Morris's burden to prove that there was an independent factor to show that he still had legal authority to be there, when in fact that's not the law. So, and I don't think we want the instructions to be very crisp and very clear, because we don't want to risk the things that might happen like that in the jury box.
I agree with you that that's really important when we have an instructional error issue, but when you think about this case and the amount of evidence, there was evidence on all the different ways that you might look at the additional specific factor. And it's, if we're just asking whether there's a substantial probability that things would have come out, a properly instructed jury would have done something differently. I hear you that things can happen when the jury sees the right instruction, but in this case, isn't it kind of hard to imagine a particular jury in every one of the scenarios you pose not still saying, well, there are just so many facts about the need for, filing the petition through the booth and all of that it's hard to imagine that it would come around to an acquittal or a hung jury.
Right, so I would, if I could have a little leeway, just because I don't want to be disrespectful here, I think a reasonable juror could come to the juror box with the schema of government workers are on the front lines with dealing with the public. They do yeoman's work. It's a very difficult job. The volume of their work is high. They go above and beyond, right? And then so a juror can bring that schema into the juror box. I could be, I'm not talking about me, but I could be a reasonable juror. I could say my interaction in places like, in other contexts, is not positive when it comes to bureaucrats. I get ping pong back and forth from one agency to another. And all of it doesn't seem like it's because they want to go above and beyond. It's because they don't want to deal with me. Because it's common in the phrase these days, everything is a nail to a hammer. Everything is a wrench to the machine. So when I come to the jury box, I see myself in Mr. Morris, and I see Mr. Morris coming to first of all, I see that same type of inconsistency that I see with other bureaucrats when they say there's testimony that he can be in there, he can be asking questions, and then there's this policy that says he can't be in there because he can only file at this anthrax post. Those conflict, and that's
why do they conflict? I mean, they're they're related but distinct. One of them is if your only reason, one of them would say, if you come in and you say, I'm here to file something, that's my only purpose. Then an officer could say, well, this is not the right place to do that. If you're not an attorney, you need to go out and do it at the booth and then we'll accommodate you. That's one thing. If someone comes in and says, I have some questions about filing, then you might have a business purpose and you could start talking. So why are those two policies? You can be there for legitimate business purposes. If your purpose, however, is solely filing, the way you do the filing part of your purpose, or if it's your only purpose, the way you do what your business is out at the, initially out at the police booth. Why are they conflicting?
So I'm coming to ask a question about maybe a letter I got from the clerk of the court about a previous filing. I'm in there. I'm asking a question about my previous filing. I'm asking clarification about this letter I got. The government says you can't be in there because you can only serve your brief. You can only file
I
your
didn't
petition.
understand. When you say the government, do you mean the government at argument, at trial, or do you mean in their brief, or do you mean the police
sorry.
officers, or who do you mean?
One policy is saying you can only be in here. And I think this was the sort of theory that at trial the government was advocating for. You can only be in here if you're filing your, if you're not filing your petition, you can't be in here. I do think that, so if,
That
sorry.
doesn't seem to be consistent with what they were, I mean, they spent a long time talking to him, and answering his questions, and, you know, he wanted people arrested, and they told him, if that's your business, that we're not going to do that. He wanted to speak directly to the clerk of the court, and they said, we're not going to do that. So if that's your business, the answer to your request is no. But I didn't understand that the officers communicated to him, you have no right to be here, because if the only thing you can do is file, and you've got to do that out at the police booth. I didn't understand that to be communicated to him during the incident. I didn't understand that to be the government's position during the trial, and I don't understand it to be their position in this court. So I'm not quite sure about your argument that there are conflicting policies. I agree that it's kind of confusing. There's this, to the extent he had multiple purposes, there were different policies that had different implications. So I can see that gets a little complicated, but I didn't quite see the conflict. So I haven't quite gotten it yet.
right. So I agree with you. I don't think the officers put that to him during the event. I do think that the government was offering it as an independent factor to say, listen, he came to file a petition. He was supposed to do that at this booth. Therefore, he shouldn't have been in the clerk's office to file a petition. Therefore, he didn't have a business purpose to be there. And so
I guess my problem is I don't see. I mean, I just wasn't aware that this was wrapped up in the additional specific factor. Like, this seems like the argument now has shifted, right? The additional specific factor is there some objective basis that underlies the officer's order, you have to leave, right? And the government, I think, in closing said, okay, there has to be an additional, I mean, they didn't use the words additional specific factor, but in their closing argument initially, they said, look, there's a sign that says for business purposes only, and they mentioned that multiple times in their closing. And then they talk about the fourth element and say, he didn't have lawful authority to be there. For business purposes, doesn't include filing. It could include talking to the clerk and asking questions, but it doesn't include filing. And he made it very clear that all he wanted to do was get people arrested or file something. So once that became clear, he didn't have a legitimate business purpose to be there, and also being disruptive is not allowed. So the government puts it to the jury as there is an objective basis for the officer to issue the order for these reasons, right? And the defense, in closing, doesn't dispute that those objective reasons are legitimate reasons, right? The defense just said, well, actually, he just wanted to talk about his pleadings. Like, doesn't, as far as I could tell from the defense closing, like, didn't contest the government's argument of like, no, he wasn't, he was only trying to file something. The defense doesn't acknowledge that argument. And then, contests that he was being disruptive. So sort of takes the government's argument on its own terms as far as what the objective basis for the officer's order was, and says just factually, those aren't true. And then the government comes back and says, look, the defense is arguing that the officer was, acting on a whim and ordering him to leave and then arresting him. And that's not true for these reasons. Here are the objective reasons. Like, that's how this case was tried to the jury. And so I just don't understand if your argument is the instruction was wrong. And, for sake of argument, let's say we agree the instruction was wrong. But on this case, in this case, on this record, it seems like the jury was told by both sides, this is how you should decide the case, that you should find an objective factor underlying the officer's order, and that these two things would have been an objective factor. And we're just arguing about whether the facts substantiated an assessment that he had violated these rules. We're not arguing about whether or not these rules exist. We're not arguing about whether these rules are sufficient to provide a foundation for the officer's order. We're just arguing about whether or not he actually was disruptive, or he actually was just trying to talk to the clerk and ask questions. That's how the case was presented to the jury. So I'm just struggling to figure out like how we would say that, even assuming that the instruction was wrong, that your client suffered any sort of harm.
Well, I mean, to pick up on Your Honor's reference to the closing, I think there, as an aside, the prosecutor says something like, I'm just paraphrasing. He says, not for nothing, but we're not talking about the stairs of the Supreme Court. We're talking about the clerk's office, right? And so to me, that's an example of why we don't put the, that's why we don't put these sort of ambiguities into the jury box. We don't, into the deliberations. We say, we're keeping that stuff out because we're going to give you a clear message so that you don't get off on a tangent and think, well, hold on, maybe since it's not on the steps of the Supreme Court and it is in the clerk's office, maybe we can just say it was enough that the officers said.
But that's just not how the case was presented to the jury. Like, the government acknowledged we have to, I mean, in sum and substance, the government acknowledged we have to show you some policies. And here are some policies. You can't be disruptive. You have to file with the guards booth. You can come and ask questions, but you can't file in the clerk's office. Those are policies. The defense didn't dispute that those policies existed, right? Didn't dispute that they would be a sufficient basis for an order. Just said on these facts, like, he wasn't actually being disruptive. He wasn't actually trying to file something. He was just trying to ask for advice. And that's how the jury heard the case. And it seems speculative on this record to think that the jury kind of went off and was confused about this factor.
Okay, I think on this record, we can't speculate what the jury might have taken some maneuver in logic that sort of contradicts things like the burden of proof, things like that. I think if there is room, we have the jury instructions to remove any dangers of that. And I mean, there are a number of things that maybe they were divided as to which independent factor did in fact exist, in which case that would be problematic because of the Scarborough case I cited. There's lots of
Well,
problems.
that spins out into a lot of complexities not raised in the trial court. So leaving aside that complication, I mean, I get your point that I mean, in an ideal world, if the jury instructions would be very clear to the jury and you wouldn't have to wonder about, whether the jury took what you could think of as a shortcut. That your idea is maybe the jury got back there and started talking about the way the parties had framed the issues and thought, why do we have to worry about any of that? Let's just look at element 4 and it says legal right to remain and an officer said to leave. So the end. That's theoretically possible. I take that point. But if we're reviewing under plain error, its theoretical possibility isn't enough, first of all. And then second, that sometimes the way we frame the standard is if the jury had been instructed properly, is there a reasonable probability that the outcome of the proceeding would have a different meaning? Let's say the jury had been told there needs to be an additional specific or specific additional factor. And for example, and more specifically, even here are the 3 that the United States is relying upon. So why don't you analyze them? I'm just struggling with why we would think there's a reasonable possibility that a reasonable juror would have acquitted. And just to spin that out a little bit, as a first step, would you agree that there's not really a reasonable possibility that a reasonable juror would have acquitted on the following theory, that the defendant wanted to file something and could lawfully just stay there and file it? Do you think that a properly instructed jury, a reasonable, properly instructed jury would not have acquitted on that theory? Because it was undisputed that there was this policy that you had to go, what you wanted to do was file, you needed to go elsewhere to do it. So that wouldn't have been how they would have acquitted. Do you agree with that?
Are you saying, I think they could have acquitted based on the policy that you can only be in there to file.
Oh, I don't think there is a policy that you can only be in there to file. So I think there's a policy, as I understood it, there's a policy that if all you want to do is file, there's a place elsewhere where you need to go do that. So I'm just saying they wouldn't have acquitted on the theory that he wanted to file something and it was fine for him to stay there to do that. They would have had to have a different theory to reasonably acquit, which is he wanted also to talk. Do you agree with that? A theory of acquittal would have to rest on the idea that he was staying there to do something more than filing.
I think, so one hesitation I have towards that is he actually did go there on a previous occasion, and I'm not sure he didn't file using the sort of technical term, but he gave his petition to an officer in the clerk's office. So a jury could say, wait a minute, this is claimed as a policy, but I'm actually not sure it is a policy.
Although that theory wasn't spun out at all in that theory was not presented, I don't think, to the jury in closing. That line of thinking, was it? Sort of it's a policy, but it's not consistently enforced, and therefore it shouldn't be treated as a specific additional factor. Interesting legal question, but I didn't think anybody spun any of that out. Anyway,
well, no,
I got that line of thinking. So let's say I think I understand that concern. Spin over to legitimate business purpose. Undisputed that there's a sign that says that. And so I just want to make sure if you're thinking, here's how a reasonable jury would have acquitted on this line of thinking, the idea would be he wanted to talk, he had a set of requests, he wanted people arrested, he wanted to speak directly to the clerk. So he's there, it's not like he's talking about sports or anything else. He's there to have conversations and make requests relating to the business of the clerk's office. So he has a right to be there. That's a line of thinking for sure that a jury could well agree to a point. And I guess the question is, the way the facts spin out here, it seemed to me that the officers were quite patient with him and he made various requests and they explained why they were unable to accommodate those requests. And then they said, okay, if there's nothing else, you need to leave and you can't file anything. And he said, okay, then arrest me. So what would be the thinking of a reasonable juror who would say, no, I think the officers had no basis to enforce this specific additional factor of he doesn't have a legitimate business purpose anymore. They've had the conversation that they're going to have. They've addressed his concerns. They've told him he needs to leave. He's been there for, I think the chief of police came and it was still 30 minutes until after, I don't know the exact time frame, but he was there quite a long time. And so just walk me through how a reasonable juror would have said, I think there's just no specific additional factor here relating to him not having a legitimate business purpose anymore. What would the thinking be?
The thinking would be, Mr. Morris has come to the clerk's office of the Supreme Court. He wants to speak, one of the things he wants to do is speak to the clerk of the Supreme Court. He's initially met with some bureaucratic resistance. There's testimony that one of the clerks went to go get the police because my client was just being there. Like, he was just standing there. And there's a number, at that point, he could have been sort of flabbergasted, like, wait, I'm in the clerk's office of the Supreme Court and I can't speak to the Supreme Court. What's my next move? How am I going to deal with this? And then the person goes and gets 5 police officers. And then they say it's my client who's being disruptive. A reasonable juror could do that. And I'm pushing back a little bit on the references to what was or was not developed at trial, because once we're talking about harm, we're talking about what jurors of, reasonable sense could come up with in the deliberations on their own. They could make these theories. So it doesn't matter that some things weren't brought up at trial, in my view.
It seems to me it's relevant, but not dispositive. So we may agree, it seems to me it's relevant the way the issues were presented to the jury, but it may not be dispositive
Okay.
if there are risks that weren't developed that are sufficiently great to show a degree of prejudice as might be required under the plein air standard. So I agree with you if your point is not dispositive. I'm not sure I agree if your point is it doesn't matter. It's not relevant.
Okay.
Can I ask a question? Assuming, you're pushing back a lot on the substantial rights prong. If we agreed with you on that, but we were still doing a plain error analysis, how do you get to plainness on the issue that you're raising on appeal now, if you kind of admit it's been an unresolved question?
I think something can be both plain and unresolved. I think that's sort of what's happening in this case. Nicholson is the grandfather of the independent factor, right? And it sort of, it laid down the law, I think it was the late 60s. And the government has conceded there's not an issue about whether the independent factor actually should apply in the Supreme Court clerk's office. So we know that it applies. And so that leaves us with Hastie. And Hastie is 30 years old at this point. And there's no reason why, if additional proof is required to narrow a statute regarding demonstrations in the Capitol grounds or a Capitol building, why, and that needs to be found by the jury and adequately and appropriately instructed, why that wouldn't be true for the independent factor.
Right, but the government seems to think it's encompassed within the 4th element. Right?
That can't be the law. If that's what gets me stuck on that is I look at the unlawful entry instructions for private property, and I look at the unlawful entry instructions for public property. For all intents and purposes, they're exactly the same. And I don't see how that can be possible if, for one, you need to prove more than the other. So I see my time is up, but
Okay. We'll give you your 3 minutes on rebuttal. Thank you,
Thanks.
Mr. Burgess. We'll hear from the government.
Good morning, and may it please the court. Amanda Claire Hoover for the United States. I want to start by making 3 points. First, Mr. Morris waived his claim of instructional error by first affirmatively requesting language that did not include an additional specific factor requirement, and then by actually agreeing with the government that the Red Book language in element 4 of the model jury instruction was sufficient to encompass the additional specific factor requirement. Second, even if this court were to find that his claim was not waived, it was not error, much less plain error, for the trial court to read the jury instruction in element 4, which encompasses the additional specific factor requirement. Namely, that element states at the time the defendant was directed to leave, he did not have lawful authority to remain. That illustrates that the direction to leave and the lawful authority to remain are two distinct concepts. And third, Mr. Morris cannot show that his substantial rights were violated because there was ample evidence and argument before the jury of this additional specific factor. Specifically, the Supreme Court Clerk's Office's policy that non-lawyers were not allowed to file inside of the clerk's office, but instead had to go to this police booth. As counsel acknowledged in oral argument, this was an issue that was well argued to the jury. It was aired, and there was ample evidence of it. And so it would be nearly impossible for him to say to establish that his substantial rights were violated in a way that, compromises the integrity and the fairness of the trial verdict, when this was so plainly the issue that the jury was
Are you
presented with.
assuming though that the jury, just starting with your last point, that the jury bought off on the, you can talk, but you can't file theory? I mean, the government had multiple theories, so why would we assume that?
So the government had multiple theories that were sort of interlocking. So one of these policies was the clerk's office does not accept filings in person from non-lawyers. There was ample evidence of that policy. It was communicated via a sign outside of the clerk's office. Mr. Morris, I think, even acknowledged. it was-
Right. I understand all that. It's just that, the government in its initial closing says, hey, for business purposes only might mean talking, but doesn't mean filing, and he's being disruptive. And then in rebuttal says, the defense's argument is that the officer was acting on a whim. There are 3 reasons that is wrong. And one of them is that, you can talk, but you can't file rule. And then the other 2 are, well, maybe there was only one, but it's that he was, causing a disruption. But, you seem to be assuming, getting back to my question, that the jury bought off on the theory that the officer's order to leave was justified based on this you can talk but you can't file rule, and I'm wondering why you're assuming that. Or if you're not assuming that.
So so the government is not assuming that the jury bought any one of the 3 rationales. The only thing that the government had to establish was that one of those rationales established the defendant's lack of lawful authority to remain there.
So just to interrupt there, so I understand, the jury doesn't have to agree on a rationale?
So the government believes that the jury had to ultimately find what's articulated in element 4, which is that Mr. Morris lacked lawful authority to remain there. The jury could have believed that any one of those rationales provided that lack of lawful authority. Given the evidence and the way that it was presented before the jury, the evidence and the argument most clearly supports one of the first 2 theories, that he, could not be there to file a petition. And the second theory, which was sort of that even though he could be there to ask questions or could be there for business purposes, he was not asking questions. That was one of the arguments that the prosecutor
So
made.
can I just clarify? I don't want to get you off course here, but because in your brief, you so much say, well, the jury did know it had to find an additional specific factor because of all the arguments and the way the case was tried. And that argument sort of suggests that the government agrees that this is required. And if it is, how is that encompassed within the 4th element?
So the government agrees that an additional specific factor establishing his lack of lawful authority to remain there did have to be established.
But not that it had to be instructed on.
Not that the specific language, additional specific factor had to be used. What ultimately the case law focuses on is that there's this sort of objective rationale establishing the person's lack of lawful authority to be there. And so that's why when the government initially pointed out in response to the proposed jury instruction, actually this is already in element 4. Element 4 says at the time the person was directed to leave, they lacked lawful authority to remain.
But why do you think that that language in the fourth element, lack of a lawful authority to remain, really conveys this idea that it can't be on the whim of an individual officer?
So I think reading element 4 in conjunction with element 2, which states that the person was directed to leave, makes clear that there is a distinction between the direction to leave and whether there is actually lawful authority to remain
Why
there.
is that? I mean, it seems like you're applying to the jury instructions and thinking that a jury would apply to jury instructions like a canon of statutory construction about a canon against a superfluity, so that, the jury would infer that did not have lawful authority must add something to the first part of 4 and the earlier part of 2. And I just am wondering how realistic an approach to jury instructions that is. I mean, do we have cases that say or reflect the idea that, of course, the jury would understand that there's something more required, whatever it is? And I don't know that they know it have to be specific or additional necessarily. Do we have cases that sort of interpret jury instructions by applying a canon against superfluity type inference? Because that seems a bit strained.
I would think about this a little more as a matter of common sense when you're a juror and you're presented with 7 numbered elements. And they're numbered, and the court very clearly instructs you, you have to find each of these elements, and the government has to prove each of these elements beyond a reasonable doubt in order to find the defendant guilty.
But
then-
one could take the opposite tack of saying, 7 elements is a lot to throw at a jury. And it's just not really clear what the difference is. I mean, by the time I've gotten to element 4, I've sort of forgotten what element 2 was. I guess they got them, in writing, but, it's just confusing. You're giving the jury a lot of steps and you're not really explaining what step 4 is, like not really the gist of it, which is this can't be on the whim of an officer, right? Like put aside the language that I already think is very confused, independent factor, additional specific factor, that's all kind of gobbledygook. The issue is, can the officer just do this on his own personal whim, or does he have to have some objective legal basis? And it's not really communicated in element 4.
I would dispute that it's not communicated in element 4, especially in conjunction with element 2. When element 2 says the person was directed to
I mean,
leave.
take a look at element 5 too, right? Like element 4, it says, she didn't have the lawful authority to remain there. And then you go to element 5, she knew or should have known she was remaining on the property against the will of the person. And that sort of seems to elide the concepts there, right? Like suddenly we're no longer in the objective factor. We're back in the subjective, like the person who has the authority, who's the person who's telling them to leave, the police officer, it's their subjective basis, right?
So the jury instruction
Or
does.
their will, I guess. Is
So
what
the 7
language is.
elements of the jury instruction do, of course, sort of go back and forth between what's objective and what's subjective. Of course, element 5, as you mentioned, is this sort of subjective mens rea of whether the defendant understood that they, or should have understood that they had been told to leave. But element 4 is what encompasses the
I mean,
objective
that
basis.
it's a mens rea element, but the jury might look at it and say, oh, we're talking about what the will is of the arresting officer. Because that's what the language is, right? It's against the will of the lawful occupant or the person lawfully in charge.
But the
And
first
you've
part of
just taught, I mean, it just, I
The
would
first
think a
part of-
jury would have a very difficult time looking at this instruction and think, oh, I'm not supposed to actually think about what the individual officer, has decided or hasn't decided as far as the lawfulness of this person's presence in this public space.
So to the extent that we have any questions about sort of what the jury would have read, sort of reading these without, in a sort of vacuum without this case that was presented in front of them, I think that's why you can look to the evidence that was presented to the jury, as well as the way that this was argued to the jury in the closing argument, where all the parties acknowledged that the government has to prove not only a direction to the person to leave that they understood, that sort of fifth element, but that there was an objective basis or multiple objective bases establishing their lack of lawful authority to remain there.
I get your case specific point, but before you move off it, I have a related question, I guess, about the instructions more generally and not in a case specific way, which is whether the United States has any objection to an opinion of this court that would say that, you know, whether whatever was done, or whether it was adequate or not adequate, or whether it was plainly inadequate, in the future, jurors should be specifically told, let's say, taking the word from, this is a paraphrase, but take the language that's in the comment to the current Red Book version, which is, in addition to any independent of an express order to leave the premises, there exists some additional specific factor establishing the lack of a legal right to remain, such as posted regulation signs, fences, or barricades. Does the United States have an objection to that being a part of the jury instructions?
So it could be a good practice going forward to include that language in the jury instruction, whether as a supplement to element 4, if there were any concern about it being confusing. And that brings me back to sort of why this case should be considered under the invited error doctrine, or at most the plain error doctrine, because that language was plain. It was in the in the comments to the jury instructions. And then trial counsel never asked for that language. That language that he asked for was all that was duplicative of element 4 in the jury instruction, which was talking about some lack of a legal authority or lack of a legal right to remain. The fact that the trial counsel had read all of that case law, cited all of that case law to the trial court, and then put forward a jury instruction that he believed was sufficient, which was talking plainly about the lack of a legal right to remain, not referencing an additional specific factor, not referencing posted notice, regulations, signs, etc., all goes to why this is invited error, because he had read all of the case law and he wanted to focus the jury on the lack of a legal right to remain, or rather his client's belief in his ability to, his legal right to remain, rather than this sort of objective basis, which was very clearly in the evidence. There's really no dispute in the evidence that the Supreme Court had this policy that would serve as the basis for, or that would serve as the basis for someone not lawfully being in the clerk's office, namely that they had to file outside of the clerk's office at the police booth. And so that's why this court should consider this as a waiver, because even given all of his understanding of the case law, his review of the facts of the case, trial counsel elected to pursue a jury instruction that focused only on the language lack of legal right to remain. And then when the government pointed out that that was already incorporated into element 4 of the jury instruction, he said, I agree, I concur with the government, and element 4 is sufficient. And so at most, this court should review this under plain error, but the government believes that this is actually this is one of those rare cases that is a pure invited error, because this is an affirmative request from defense counsel for language that doesn't reference an additional specific factor or any of the sort of posted notice, et cetera, that's in the comment to the jury instructions. I will wrap up by saying, even if this court does consider this on plain error, I think the question that was asked at the end of appellant's argument about why we should consider this plain is precisely why this court should affirm. Appellant makes a concession in their opening brief that there is no established case law requiring language about additional specific factor.
Why do you think that is? Why do you think this is evaded review as it has?
I wouldn't say that it has evaded review. There is ample case law about the additional specific factor requirement and the types of things that could or could not be an objective factor. The fact that no one has raised this jury instruction issue may mean that, you know, there is usually ample evidence of an additional specific factor of this sort of objective basis, such as a sign that's easy to prove in front of a jury. And so it really doesn't come down to the jury instruction.
But you kind of agreed that it'd be a good idea to give this instruction.
I'm not saying it necessarily would be a good idea, but it could be a good practice going forward if there were ever a dispute about whether there sort of is the existence of this additional specific factor. In this case, where there's ample evidence of that additional specific factor and it's really not in
But
dispute.
You say, I guess your argument is that the fourth element encapsulates this, but where, at this trial, where was the moment where the jury understood that it needed to find an additional factor?
I think as appellant pointed out at the beginning of their argument, the additional specific factor requirement was aired throughout this trial. It was in the openings, it was in the evidence, it was in the
Right.
closing argument.
But, we have a lot of cases talking about how those are not the judge's instructions.
And I think that's why all of those provide sort of additional context to what's in element 4, which makes clear that there's a distinction between the direction to leave and the lawful authority to remain. If there are no additional questions, I see that my time has elapsed. I would ask the court to affirm.
Okay, thank you. Mr. Burgess, we'll give you 3 more minutes.
Thank you, Your Honor. I would respectfully disagree with the idea that it's a good practice to instruct the jury on an element that's necessary to convict him. I think Hastie would disagree with that. Hastie's the law. Hastie says the jury has to be instructed when a statute has been narrowed by requiring more than the evidence required that's facially on the statute. That's the law. The jury needs to be told about it. If I could just return to Your Honor's Judge Easterly's questions about White, or my reference to White, I do see that there was a discussion about how it was only the defendant's right to waive the jury. That was part of the conversation, but it was also part of the conversation that the footnote in Chambers in that case made it obvious that that's not what the judge was allowed to do. And that case relied on District of Columbia versus Wickall, in which, that was a civil case, but the District of Columbia made an extraordinary concession, which was it alone's prerogative to make. And the court still said, like, we're going to excuse us from an invited error. And I would ask the court, like, how far would that go? Like, what if this was, I cited a case from the Seventh Circuit where the issue was the burden of proof. And I'm wondering, to what extent would we say, like, okay, we're only going to put it on the trial counsel to instruct the jury properly on something as fundamental as the burden of proof, when it's the trial court that's giving that instruction. They're the font of the law. And what if it was, and this case is not that far out of that ballpark. We're talking about an element that without which my client could not have been convicted. So it just, I feel like, a lot of plain error, part of it is division of labor. Like, judges are very busy. We want them, we want to allow them space to, focus on other really important things. When everyone's talking about an element that's necessary to conviction, do we want the trial court to play a more active role in something as important as that? Are we going to get fairer, better results if we say, look, trial counsel, you can't be this passive when everyone's talking about an element and you're the one that's going to instruct the jury on that element? I submit you.
Thank you very much. Okay, thanks, Mr. Burgess and Ms. Hoover, for your briefing and arguments today. The case will be submitted. Second case on this morning's calendar is number 24 BG 90, In re Craig Butler. Board docket number 22 BD 003. Whenever you're ready, sir.
Good morning, may it please the court. Johnny Howard on behalf of the respondent, Craig Butler. And I'd like to reserve 5 minutes, please.
Okay.
Thanks. In this matter, we'd like to, I guess at this point, divide it sort of two aspects. One were the original facts upon which responsibility was found, and then move to the notion of a showing of fitness after suspension. In our papers, we challenge whether or not discipline in the nature of a suspension was required. We've sort of, I think just by the amount of days, and months that have passed, the respondent has not practiced law for more than 6 months. And now more important is whether or not the fitness requirement should have been imposed. We rely at this stage on that fitness, the Gonzalez case that was recently decided by the court. The record in this case does not articulate any reasons other than the historical facts for the discipline. There's nothing that says a fitness requirement should be imposed. This respondent had not been before the disciplinary committee on any other prior instance. This is the first time. We argued that the sort of combination of these various cases did not allow for the respondent to have what we thought would be a fair look and analysis of the facts. The matters in which the respondent focuses practice involved debts, whether it was real property, something related to real property. And there were avenues that were used not to say satisfy the debt, but to give a client a reasonable opportunity to either gather enough money to pay off a debt, gather enough time to be able to sell a property or something of that nature. But the way that once you combine all of those matters, we believe that the first one involving Mr. Robinson was something that sort of allowed the hearing committee to assume that those facts were prevalent throughout all the cases. And that was not the case. And so we don't believe that combining these and refusing to allow for severance, was proper. But when we look at—
Can I just pause you
Sure.
right there? So it seems to me that you're saying that your client was prejudiced because the hearing committee and then the board didn't distinguish between the particular cases. That seems to be inconsistent with how the hearing committee and the board wrote their orders, where they particularly identified your client's conduct in the particular cases. And I didn't see any kind of confusion between the cases or any sort of muddling of, oh, well, he did it in this case, and so therefore we're going to assume that he did these bad things in other cases. They precisely documented all the deadlines that were missed, court orders that were disregarded. I mean, I won't go through the list, but I don't see any evidence in the record that there was any sort of confusion. So what's your response to that?
Well, I think the confusion occurs in what harm was caused to the respective clients.
Well, that's a different issue. If you're arguing the clients weren't harmed, But it seems if we're going to shift to that the hearing committee and the board again were pretty specific about how opportunities were lost for the clients to seek stays, to avoid eviction, avoid having cases dismissed. So that doesn't seem terribly persuasive either.
Well, I think that once you delve further into the facts regarding what was sought to be achieved for this particular client, because usually in these matters where debts are owed, the one defense is pay the money that's owed. And none of these.
Sometimes it's let's pay, cents on the dollar, right? One of the arguments that seemed to be implicitly made in your brief was that all of these clients had losing cases. There was nothing that your client could have done for them. And so any dropping of balls that occurred in the representation of these clients, it was no harm, no foul, because they were going to lose anyway. And that seems a difficult argument for you to make,
That's not quite, the argument.
an unpalatable argument for you to make as a lawyer.
Well, it's not quite that. There are steps that could have been undertaken that did not fall within the realm of appearing in court or filing a motion for summary judgment. We in the before the hearing committee explained loss mitigation efforts or some workouts that don't necessarily fall within the stricture of the deadline for the motion for summary judgment or the deadline for appearance in a particular court proceeding. But we thought that once the hearing committee would consider all of the cases, but we're saying sort of separately, meaning in the mind of the hearing committee, if every case was being judged by the Robinson case, then that would be
There's simply no evidence in the order from the hearing committee or the board that they were considering the evidence in light of the Robinson case. I just don't see it. If you'd like me to point us to a place where you think the Robinson case infected their view of all the other cases that they reviewed, I'd be happy to look at it, but I don't see any evidence in the orders as they are drafted.
Well, the reason we say that is all the other cases, aside from the Robinson case, there was no client nor no one affiliated with the client to
No one
speak.
came to testify, but there was certainly evidence, right?
Well, the evidence.
Presented about how those clients' cases were mishandled and how filings were not made, how your client did not appear in court when directed to. I mean, there was evidence before the committee. Are you saying that that evidence was improperly admitted?
No, I'm not saying it was improperly admitted, but it may have been improperly interpreted. We don't dispute that the respondent did not appear or that the respondent did not address a particular motion. But when you look at the entire case and the hearing committee would look at one, was there a violation?
Can I ask you, I'm not quite sure even, most fundamentally, why would it be inappropriate for the board or the hearing committee in looking at a particular incident to, have in mind information about other incidents? And if the issue was, was this a single inadvertent failure or was it part of a pattern? Why would it be improper for the hearing committee to, in determining how to assess the gravity of, for sanction purposes, or how to determine whether conduct was a rule violation or not, consider other instances that might be part of a pattern? What's your basis for thinking that would be inappropriate if it were done?
Well, I think it would be inappropriate in deciding whether or not a respondent had committed a violation of the rules.
Right, I'm just wondering why you think that.
Ordinarily, more or let's say additional instances of bad conduct comes in the sanction stage as opposed to.
Well, I mean, we get many cases in this court where the hearing committee, the disciplinary council has alleged a number of violations, and the hearing committee handles and hears unrelated factually, or, you know, sometimes related in various ways, but distinct, involving different clients and different rules sometimes. And the hearing committee handles them all, and we get them all as a bundle often. So I'm not sure. I think ordinarily it is done that way, but and practically, how would this, in your view, how would this have happened in your view correctly? You think each one of the separate client incidents should have been handled by a separate hearing committee and a separate hearing, and then a separate report and recommendation from the hearing committee based on a sanction that related solely to that incident? Or would it have been bifurcated so that the rule part of it would all have been, you know, a bunch of different hearings for different rules committee, hearing committees, and then someone would have had an overall sanction requirement? How would it have worked practically? I'm not quite sure I follow.
I don't think it requires that much, but I do believe that there should have been a severance between count one and count two. And count two, there were more than, you know, one particular client. But I do believe that that was an instance where there was a spillover effect, because in count one. that
And
was
why
the-
can't we trust I mean, severance is a concept in criminal law, and at times it's a, you know, relatively significant concept there. It comes up from time to time in civil settings, but why would we not have general confidence in the hearing committee and being able to take a number of different incidents and the evidence that relates to them, and then make proper use of the evidence of each of them as it was relevant to the others, and not make improper use of it? I mean, do we have any cases that suggest that we have concerns about the ability of hearing committees and or the board to do that in a way that has ever prompted a requirement of severance?
I was not able to find any case, you know, to give complete guidance. There were a number of cases, some of which we cited, that sort of lent themselves to having this severance, especially when,
So what could you be like, what case do you have in mind that lends itself to the idea of severance?
no, I'm saying a combination. It wasn't a particular case. I was not able to find a particular case.
What combination of cases, what principles are you referring to that you think kind of in combination point towards the idea that a severance approach would be warranted in the disciplinary setting in general or here?
Well, it's sort of based on sort of the way the rules are structured. In the hearing committee, you are allowed to introduce evidence about the whatever specification of the charge, but not allowed to move, you know, towards sanction until the committee says, we believe that one or more rules were violated, and then it takes on, you know, phase two, let's say. And so here, we believe that phase one and phase two were blended prior to the hearing committee making an assessment that a rule was violated.
So you think practically here, you think the one count where there was a live witness, the one specification where there was a live witness who came in should have been severed from the rest, so that two different hearing committees would have heard the evidence of those two, and then someone who would have made a recommendation of overall sanction? Would that have been a third hearing committee, or how would that have worked practically, even if you were dividing it up as between two?
Well, we just believe that two hearing committees should have been convened for consideration.
And would they have made separate recommendations of sanction, each one making a recommendation about solely what was before it?
Correct.
I see. And I want to go back to something you said at the beginning, just to clarify an aspect of it. I think you pointed out that your client has already been suspended has already not been practicing for 6 months.
Correct.
And I just wanted to flag a question, which is, it sounded like you were maybe implying that the period of suspension is kind of over, but I know the disciplinary council had filed a notice of noncompliance with Rule 14G's requirement about an affidavit. So I think their position is that any period of suspension hasn't started running yet. Are you aware of that filing by a disciplinary council?
I am aware of that.
And you didn't file an opposition, or have you filed? Has your client filed a compliant Rule 14G affidavit?
Excuse me. I don't think that my client has satisfied the letter, that was submitted to the court.
So do you agree that any period of suspension hasn't yet started running. Although he's been
No,
temporarily suspended.
I don't agree. I don't, that's a part that I have not actively participated in, so
That's
I said that's a part that I have not actively participated in, so that I cannot give you an answer.
I'm not quite sure I follow what you mean. You're not representing him with respect to that filing by disciplinary counsel, or you have some sort of
I'm not
limited
representing
representation?
him with respect to the compliance for reentry into the bar. As I understand it, other counsel, may be assisting in that regard. But moving to the notion that a fitness requirement would have been, required. We sort of took some, guidance from the Gonzalez case, that was decided, last year. Because this record did not yield anything other than what we would consider to be the historic facts based on a violation of the rules. There was nothing else that was in the record to elevate this toward, there being a fitness requirement.
And so you say you took some guidance from a decision in the Gonzalez case
Yeah.
recently, or from last year. That's not something that, at least as I'm looking, you cite in your brief. Is that, do you have a citation to that case?
I do have a citation. 318 Atlantic 3rd, 1208,
1208.
1208.
Thank you.
And so the fitness requirement, certainly presents, what we consider to be, certain difficulties. One is, based on the facts, which involve failure to appear or failure to file. What happens when you get to, so-called seeking to satisfy fitness if the person is not practicing, law, and you look at a record? What is the guidepost by which he should, meet in order to demonstrate fitness? The way we look at this is that it appears to be sort of a two-step penalty or discipline assessed against a respondent. One where the court, imposes, a sanction, that being, the suspension. And then with fitness, that is then given to disciplinary counsel to form parameters about what it takes in order for a respondent to meet the fitness requirement. And we don't believe that on this record, whether it's viewed as, the way respondent does or the way disciplinary counsel does, it doesn't give sufficient parameters to a respondent on what does it take in order to be able to re-enter the bar. And so we don't believe that the facts in the case warrant, a fitness requirement. We believe that there had to be more than just the mere violations or the facts of violations made. And that in this case, we didn't see in this record any other additional facts that would prompt a fitness requirement.
We said in Gonzalez, the open-ended fitness requirement is intended to be an appropriate response to serious concerns about whether the attorney will act ethically and competently in the future after the period of suspension has run. And I'm just wondering, it seems like we should have serious concerns about your client where he misses deadlines repeatedly out of inadvertence, but then doesn't take steps to adjust his practices to not inadvertently miss more deadlines. Flat out disregards court's orders, right? Fails to communicate with his clients, allows, dispositive pleadings to be filed without response. I have serious concerns about your client. I'm not sure why we shouldn't impose a fitness requirement if that's how we're supposed to view it.
Well,
Practicing law is a privilege. And
indeed.
is, you're entrusting you know, when you take clients, they entrust their lives to you and they expect you to do a good job for them and to pay attention to their cases. And your client said that he treated each client like family, and the hearing committee flat out said, we don't credit that statement. He did not act that way. So why shouldn't we impose a fitness requirement in this case?
Well, I think that by having imposed a suspension for the conduct,
Right, now, we've already, suspension is water under the bridge, and what I just read to you is when we impose a fitness requirement. It's when we have serious concern about your client's ability to practice law in compliance with the ethical rules. I have such serious concerns. Why shouldn't I have those concerns?
that is a serious, anytime there is an issue regarding a violation of the rules, we believe is a serious concern. But having said that, what is the responsibility of the respondent to be able to file an application to re-enter the bar? There are no standards that are set that would, at least that we believe that could be set to say that in the future, this respondent will, meet all court deadlines, or this respondent will make sure that they have appeared at all hearings, because there is no opportunity for the respondent to specifically address those issues upon reinstatement, because he is not privileged to practice law.
Well, that seems like a general critique of the fitness requirement, because generally you're suspended. And so you can't prove during the period of your suspension that you're able to fix whatever the problems are by actually demonstrating that you can through the practice of law, because you're suspended. So that, I mean, that's an intrinsic feature of being suspended and requiring to show fitness after having had problems. But I mean, we have a fitness requirement, and so I guess we expect that folks will explain what classes they've taken, or the way they propose to change their practices, or what the nature of the other problems were, and how they have, how they expect to be able to address them. So that seems like a very sweeping critique rather than an argument that's specific to your client's situation.
Well, it's more than, or at least we didn't consider it as being a critique. But there's a small amount, let's say the rule says up to 3 years, anything less, or it's in between the 3 years. So if the respondent has been away from practice for more than 6 months, and then seeks to file an application to satisfy the fitness requirement, does that mean that that requirement, based on the facts, as the court read, allows disciplinary counsel up to 3 years to refuse an application to re-enter the bar? And so basically what we believe is that the record itself should be viewed in sort of 2 ways. One, if the hearing committee and the board and the court is inclined to impose a suspension, but then there should be some additional evidence outside of those facts that would warrant.
Let me just read to you again from Gonzalez. Gonzalez says, while the decision to suspend an attorney for misconduct turns largely on the determination of historical facts, so it endorses looking at the prior misconduct that generated the suspension, the decision to impose a fitness requirement turns on a partly subjective predictive evaluation of the attorney's character and ability. So we're looking at the historical facts and we're saying, based on these facts, and it's not just like a blanket, he missed deadlines. He missed deadlines repeatedly for particular clients under particular circumstances that the hearing committee reviewed, right? They looked at the particular facts and thought, boy, this was completely unjustified. And he repeatedly kept saying, oh, this was inadvertent, right? And made a decision that he needed to be suspended. And then the board looked at those same facts and said, we think he needs a fitness requirement. And I'm hard pressed to understand why we shouldn't agree, particularly when your client is under an order from our court under 14G to file an affidavit and he can't even comply with that order. I mean, it's pretty shocking that here he is asking not to be subject to a fitness requirement and asserting that his suspension hasn't even run, or you're suggesting that that's not an argument that's available to him, but he can't be bothered to comply with our rules.
That's not quite, I guess, the way we, would view the facts. We believe that the historic facts served as a basis for not only finding rule violations, but also to impose fitness. And we believe that the record would have to have more regarding the subjective aspect of the board's decision.
I don't understand how that could be a correct legal rule. You're saying that no matter how bad the misconduct, unless there's something beyond the misconduct, a fitness requirement is never warranted. But sometimes the misconduct itself warrants disbarment without anything more. So I can't see. I mean, I'm not aware of cases that support the idea that the misconduct itself can't suffice as also the rationale for thinking that fitness is required. Are you aware of a case where we've said that or implied that? I'm not, and it seems to me like it's hard to think it could be right.
I don't know of a specific case that sort of requires that. There are cases, I think, in Ray Cater.
I was thinking actually the Gonzalez case that you mentioned, I would be interested in what the ways in which you think it might be helpful to your client. There's some language in it that seems somewhat unhelpful to your client. I'm taking one part where we're talking about fitness and we said several aspects lead us to conclude that a fitness requirement is warranted. First, the respondent's disciplinary history shows a pattern of prolonged and repeated neglect affecting a large number of clients over a period of many years. I'm not sure the years at issue in your case, so that might be different. But the idea that a fitness requirement is supported by a pattern of prolonged and repeated neglect affecting a large number of clients seems relatively applicable to your client's conduct as determined by the hearing committee.
Well, I think what seemed to have been missing from at least the hearing committee's report, the respondent sort of came into this difficulty during a period of time that his father was ill, and his father lived in another jurisdiction, lived in New York, and he was shuttling back and forth to attend to the needs of his father, and that had something to do with at least from our vantage point why deadlines were missed or some things didn't make it to the calendar and so forth. And the respondent had to rely upon sometimes changing staff in order to be able to do that. But there was no testimony or evidence that after a certain period of time that these, aspects of his practice had not been sort of changed. And so we believe that the imposition of fitness under these facts was pretty harsh and that it was outside of the realm of, cases in this respect.
Thank you, Mr. Howard.
Thank you.
You've used up your rebuttal time, but we'll give you a couple minutes in any event.
Good afternoon, Jack Metzler, morning, for the Office of Disciplinary Counsel, and may it please the court. The misconduct in this case is clear, and there's not really any significant challenge to the facts or to the conclusion that Mr. Butler violated the rules as recommended by the hearing committee and the Board on Professional Responsibility. And as the panel has recognized, the misconduct shows a pattern of misconduct. In case after case, Mr. Butler utterly failed in his responsibilities to his clients and to the court. He let dispositive motions go unanswered. He filed defective pleadings and then didn't correct them, even when notified by the court, even when ordered to by the court. He ignored multiple court orders, and he skipped the hearings even when he was ordered to appear. And the result for his clients was disaster. The most developed case is in the record is Mr. Robinson, who lost his home because Mr. Butler failed to oppose a motion to lift the automatic bankruptcy stay in his case, where he had meritorious arguments that could have forestalled lifting the stay and saved Mr. Robinson's home. In the Clayton case, the personal injury suit was dismissed with no opportunity to refile because the statute of limitations had run. And that again was entirely up to Mr. Butler. He failed to take over, I think, 6 or 8 months. The very first step, he needed to call the court, get a draft summons, and then serve the defendant. And he was given opportunity after opportunity. The court had to chase him down and even called him on his cell phone to get him to do this, and he simply wouldn't. And the court, with great reluctance, dismissed the case, and Mr. Clayton's case was gone. He also fell down in his responsibility to the courts. As I mentioned in the Clayton case, he was given opportunity after opportunity. He was ordered to appear and he didn't show. And that was also true in other cases. And as I said, the brief doesn't offer really any credible exception to any of those findings or the conclusions that Mr. Butler engaged in the misconduct as charged. And so with respect to the sanction, Judge Easterly, you are correct to have a serious doubt about Mr. Butler's ability to conform himself to the rules after serving a period of suspension. And Judge McLeese, you are correct that the period of suspension in this case has not begun to run because Mr. Butler hasn't filed the required affidavit. But as to my friend's arguments, there is more than just what he calls the historical fact of the violations. As you point out, Judge McLeese, those violations form a pattern, but it's also true that throughout this process, Mr. Butler has never accepted responsibility for his inactions. He's never admitted blame. He has come to disciplinary counsel and to the hearing committee and the board with a set of, I can't remember if it was the board or the hearing committee said were flimsy excuses. His email server was hacked. He was in an office move. His father was sick. I have no doubt his father was sick, and I sympathize with that. But sooner or later, these excuses add up, and meanwhile, the same conduct happens time and time again. I mean, just to take one example, none of the excuses he's given explains why after the court contacted him on his cell phone and said, you really, really need to take the first step in this personal injury case for Mr. Clayton. He didn't do it. He didn't get the summons or whatever it was, and he didn't serve the client or he didn't serve the defendant, and the case was dismissed. So beyond the actual fact of the violations is his continual shirking his responsibility, refusing to accept the seriousness of his conduct. And you can see that even in his brief here. He says, well, every time I missed a filing, I tried to do other stuff. I helped them in other ways. Well, I mean, that's just no excuse. It's too little and too late. And at the same time, he blames his staff. He blames his email box. He blames anybody but his own incompetence and inability to conform himself to the rules. And then lastly, with respect to, what is he supposed to show? when it comes time to apply for reinstatement? Well, there are standards. The court has outlined those in Roundtree, and they include recognizing the seriousness of the misconduct, taking remedial steps to show that it will not recur in the future, and other things that are in the record, or that are in the Roundtree case. And the court has found that those same factors can be considered when determining whether to apply a fitness requirement. And here, there is no effort to accept responsibility, no recognition of the seriousness of the conduct. He continues to blame anybody but himself, and doesn't really, even with no defense on the facts or on the law. So the court should adopt the findings of the hearing committee, of the board, and the violations that the board concluded were established, and impose the sanction 6 months suspension with fitness. If the court has any questions, I'd be happy to address them.
Thank you very much, Mr. Metzler.
Thank you.
Mr. Howard will give you 2 minutes.
Thank you. The one aspect of the argument that Mr. Butler did not show contrition, we believe is not borne out by the facts of the record. During his testimony and his, I believe, cross-examination, he indicated that he was not a person to be at least intentionally trying to inflict harm on someone. And certainly that, those folks who believe, or those clients who believe to have been harmed by his conduct, he offered, an apology in the record. And even throughout the proceedings, while Mr. Butler indicated why certain things happened, that should not be viewed that he was a person who would shirk his responsibility. He, had done what we believe a practitioner in those debtor type cases should do. There had not been any kind of allegation that he lacked the intellectual ability to handle the substantive matters. Most of these, most of these cases, as we outlined earlier, there were no persons who came in to say that Mr. Butler had not achieved the goal or purpose that these folks, sought. In this debtor space, many times a person is looking for more time to be able to do something. And I think at least those in count 2, whether it was time to sell a property or to have a short sale or deed in lieu, those things, these clients had an opportunity to do with whatever efforts Mr. Butler employed. And we ask that the court give consideration to our arguments in the brief, and certainly reach a different conclusion than a suspension in fitness. Thank you.
Thank you very much. The case will be submitted.
All right.